Welcome back to Good Law, Bad Law. In this episode, my guests are education lawyers Josh Kershenbaum and Grace Osa-Edoh. We're talking about the Take the Knee protest that we've seen many professional athletes and especially football players engaging in, and now reaching into high school and even elementary school students. Does the First Amendment protect public school students' right to take the knee in protest? Stay tuned for this episode. I hope you like it. My guests on this episode are Josh Kershenbaum and Grace Osa-Edoh. Thanks for being with us today.
Thanks.
Thanks so much.
We are going to have a really important and fascinating and very topical conversation today about the First Amendment rights of students. But the context for this is so explosive right now and almost, is taking on such incredible dimensions around the country, starting with a former 49er football quarterback, Colin Kaepernick, taking the knee during the ritual playing of the national anthem at a football game, and spreading to so many other football players and other professional athletes, and now spreading into schools as students take part in this form of protest. So we want to talk about that, the First Amendment and the rights of students, with two lawyers, Josh and Grace, who actually in their law practice spend a lot of time working on cases involving students in the school system. So I really appreciate both of you being here for that. Josh and Grace, maybe you could just start by telling us a little bit about yourselves and what you do, and then let's get into it.
Sure. Well, we both are attorneys at Franklin Kershenbaum, which is our law firm that represents children. We represent young people, students in school, college and university students in all manner of law, with a heavy emphasis on representing kids that are in disputes with their public schools over things like the provision of special education services, sometimes over issues of free speech and other constitutional rights. So our entire practice is devoted towards representing students, children, in all varieties of law.
And Grace, what about you? What are some of the cases, not the names of the cases, but some of the types of cases you work on?
So I typically work with school discipline. I work with kids who are about to be expelled or are facing suspension or multiple detentions. I also do a few cases in higher education. We've actually had a couple of First Amendment cases come up. And generally, like Josh said, just anything dealing with children and families and helping children advocate for their rights but in conjunction with their school districts, their educational institutions.
Okay, and we're talking about the big issue here, which is, at the highest level, we're talking about the First Amendment and that part of the First Amendment that guarantees the right to free speech. And we've seen, forms of protest all over the country now, in the form of taking the knee, which is how we've come to talk about it. And this is such a big issue right now in our politics and in our culture in many, many different ways. We had Reggie Shuford from the ACLU on this program a couple of weeks ago talking about the aftermath of Charlottesville, the protests there, and the ACLU's role in defending free speech rights, even for those who are speaking things that many of us might find reprehensible or hateful, like the Nazi Party marching in Skokie, Illinois. Here we're obviously talking about a very different message, but the form of protest is really what is so fascinating, and that it is spreading into our school systems, and that you mentioned discipline, that school children are already starting to be disciplined for exercising free speech. So I guess, Grace, maybe you could sort of help us set the table and understand a little bit of the background of this Take the Knee protest. Almost feels like a movement at this point. I don't know if anyone's calling it that yet.
I think they should. They should start.
But it does seem like that that a movement has begun.
Definitely.
And so give us a little bit of the background so we know what we're talking about.
Yeah, Aaron, as you said before, it started with Colin Kaepernick. He was on the San Francisco 49ers. He takes the knee. He started taking the knee in 2016, I believe, and he did it in protest. He was protesting the treatment of Black and brown people in this country, and it was a silent, personal protest that, you know, we're calling it taking the knee because literally all he did was bend down during the national anthem, and from there it just kind of exploded. Other NFL teams are doing it now. Teams in the NCAA, which is the college level, high school athletes, even other sports. Recently, we saw teams in the MLB, the WNBA, and a NASCAR driver spoke out about this issue. So that's why I think that now we can kind of call it a movement, because not only has it gone out of the NFL into other sports, but even separate from sports, we have high school students, middle school students, elementary school students taking the knee during the pledge or the national anthem in class. And it's a different form than sports because, and we're going to talk about this later.
Yeah, it's different when we're talking about kids in school. We're going to get into that.
Right. In sports, you are, depending on what level of sports you're participating in, it can be school sponsored, it can be in a public forum. But when you're talking about students in school, the right to protest is a little bit different. It's not so limited that you don't have a right to protest, but there are certain parameters that students have to stick within.
And these are cases that have gone all the way to the Supreme Court in this country over a lot of years of our history. And so, and we're going to talk specifically about some of the leading cases, because as we look at what's happening around the country, and you mentioned professional athletes and even college athletes, but it's beyond even that at this point. There are musicians like Stevie Wonder took the knee at a concert in support of, in solidarity with, you might say, some of the professional athletes who have led this protest, and others. So it's culturally and in our culture, in the arts, in sports, this is something that's growing. I know, one of the big questions is, I think, going to be not just the right to protest, but the form of the protest. And these are issues that become so emotional because they get at values and ideas and beliefs that people have that are so close and personal, maybe religious, maybe to a sense of what people think it means to be an American. And Josh, we've seen this in our history, not just recently, but for decades, whether it was protests involving the burning of the American flag, or
the Vietnam War,
protesting the Vietnam War, musicians, getting political at their concerts. I know, there are people who won't go to a Bruce Springsteen concert because he's become so identified. His personal politics have become so identifiable, and there are those people who will shout, "Just play the damn music, Bruce." I don't want to hear. So, or people who talk about Hollywood, Hollywood stars getting involved politically. So we people are very passionate about this, but at the same time, it's as American as anything else, right?
I mean, you hit the nail on the head. I mean, this is not new. America is a country that was started with a revolution, and it's been a very political country ever since. Americans are very political. They're very opinionated. We're very passionate about our ideas and our ideals. And it's not a coincidence that the very First Amendment to the Constitution is all about preserving and protecting that character of America as being a place where it's okay to express your opinions and where you're safe to do that. And that has taken on different forms over the years, but we see it. It's so interesting when you look at the cases, First Amendment cases, particularly student First Amendment cases, are some of the least boring cases you'll ever read. They're some of the most interesting. Some of them are actually downright funny in some cases, about how the very American tradition of protest has manifested itself in schools. And it's not a coincidence that the most important landmark cases that the U.S. Supreme Court has dealt with occurred during times of great social unease, usually wars, World War II, the Vietnam War. The two big cases that we'll probably talk about the most came about during the height of the Vietnam War and just after World War II.
Just
Right.
before.
During World War
Just
II.
before World War II and during.
1943.
Right.
Right.
Yeah.
Right.
So that's not a coincidence. And we'll talk about this, I'm sure, but it is not a coincidence that this issue is now coming up today because while we are at war, we've been at war for a very long time, but also there's no question that Colin Kaepernick started to do what he did because he realized and he recognized and he was extremely concerned about what he views as being effectively a war in this country against Black and brown people. And it's happening at a time when America is feeling more, in effect, divided than ever and uncertain about the future of our civic dialogues. It's not a coincidence that this is happening now. That is the entire story of these cases that go through the courts.
Yeah, I mean, I think some might say that the characterizing what's going on as a war, is maybe an extreme way of putting it. I would probably say that too, but I think clearly that we are in a period of great
Social unrest.
The passions, attention in the media, in discussions around the table, in our courts, whether it's another white police officer shooting an African American man pulled off to the side of the road, or whether it's a debate over the Confederate flag or Civil War era Confederate leaders and their statues on the public square. I mean, these issues are, the civil rights movement is not over. We are in the midst of intense debate and political,
Right.
maybe even turmoil right now. And
I think
so. These issues you're right, are coming up in a time of intense social and cultural and political feelings on these points.
Yeah. I mean, I think what it's starting to show us is that the civil rights movement, as it were, is not an isolated thing that happened during, the 60s. And, this entire history of this country has been a struggle to figure out what civil rights are, what is the character of this country, who gets to have these rights, what rights. The entire history of this country. I mean, look at the Constitution. The Constitution has been amended a whole bunch of times. And every single time that happened, it was all about a struggle to figure out what is the character of this country? How do we get along as 350 million people from all over the world, speaking, hundreds of different languages and being all sorts of different colors and shapes and sizes? That has always been the history of the United States. And what's going on right now is a natural continuation of that. All of the cases, all of the issues with the First Amendment, it's all about how do we express ourselves? What are the parameters?
What are the limits?
What are the limits, right?
Mm-hmm.
Because there's this notion that this is America. You can say whatever you want, whenever you want, and the First Amendment protects it. That's never been true.
Not quite right.
There's always been limits on speech, whether in school or out of school. Even in the public square, there have always been some limits. The question really is, which limits are there going to be?
And I think what is so challenging for anybody who has a particular perspective on a particular issue. You might say, I support Colin Kaepernick. I support the Detroit Lions. I support, a high school student taking the knee in a school. I like what they're doing. I support that message. Or I agree with the kid who wore an armband in protest of the Vietnam War. We're going to talk about the Tinker case. But if you support that, and the basis for that is not just, I like those views, but I believe in the right of that individual to express those views, because we have this thing called the First Amendment. You also have to, if you're going to be consistent about your views on the First Amendment, you have to be willing to accept speech that you don't like.
Right.
Definitely.
That's always been what the First Amendment is about. It's about protecting speech we don't like.
If you think, go counter protesters speaking your mind against the white supremacists in Charlottesville, you also have to be willing to say that the white supremacists under the First Amendment, even though I don't like what they have to say, have a right to say what they say.
Right.
Within limits, of course, because the First Amendment jurisprudence has always been my right versus your right, or free speech versus safety. So that's how we saw the development of our hate speech jurisprudence. Like, you have the right to say what you want, but not if it either very predictably leads to violence against others, or if it's advocating for violence against others in a way that will harm all of us. So I think that's one limit that we always have to keep in mind, and that's what schools have to keep in mind.
I agree.
Safety.
I mean, there's no question that there is a concept called hate speech that's now part of our conversation.
Right.
But I think the courts have been pretty careful to protect hateful speech. I mean, you're right. It's not an absolute right under the First Amendment to any kind of speech, including hateful speech. But the courts, I think, have been pretty careful to say, unless speech is, in the words of the Supreme Court, presents a clear and present danger,
Right.
is designed to incite violence, even hateful speech, and that's what Reggie Shuford from the ACLU was talking about a couple of weeks ago. Even speech that is hateful, is reprehensible, is abhorrent, is protected under the First Amendment. So, I mean, I think where it gets really dicey is if you're carrying a semi-automatic weapon on your hip.
Or a tiki torch.
Or a tiki torch, which and I think both sides in the protests in Charlottesville, came to armed in certain ways, and that presents all other problems too. I think, but that's a whole other conversation. I think is when you're carrying guns, what's going to happen to your First Amendment right.
Right.
But there can be lots of limitations on people carrying guns. It sounds a lot closer to speech that's designed to incite, I think, when you're packing heat and
Definitely.
speaking.
Right.
But let's talk about schools, because that's, because children have, we were talking about this before we started. I think there are a lot of ways the law doesn't treat children the same as adults.
Right.
Many, many ways. I mean,
Well, let's start with the fact that there's even there's a legal concept called child.
Right.
Yeah.
That the law makes a distinction that our society makes between this thing called an adult and this thing called a child. Even that construct is a distinction,
Right.
and it's the most natural distinction in the world. We don't even question it,
Right.
but it is a legal
we
construct.
call children minors.
Minors, and they can mean different things in different contexts, and you can be a minor at 16 in some contexts, or at 18 in others, and 21 in others.
Right.
But even this whole concept of a child is, in this conversation, it's a legal construct, and so that comes into the schools along with the children. The law comes into the school with the children. Society comes into school with the children. Children don't cease to be Americans or people
Right.
living here and living and breathing the culture that we have. They don't stop being those people once they walk into school. But the courts recognize that there are some practical and social differences between being in school and not being in school, being outside of school.
Well, now we're into it, Grace. And we've seen students, following the lead of these athletes who are engaging in this form of protest, engaging in almost exactly the same type of protest, but within a school. To understand whether they have the right to do that, or whether a school district has the right to discipline a student for exercising what that student may consider to be a First Amendment right, we have to look at two very important cases from the Supreme Court. One's the Barnett case,
Yes.
which, as Josh mentioned, came out right in the middle of World War II in 1943,
43.
and the Tinker case, which came out right in the heart of the Vietnam War era,
60s, right?
1969. So let's talk Barnett first, just because it came first, and then let's talk about Tinker, and that, I think, will help frame, our understanding of what's going on right now. So start with.
And Aaron, I don't know if this is the time to say it, but I think it's worth mentioning. We're really talking about this in a public school context.
Yeah.
I think it's an important distinction to make right up front, because, to the extent that there are students listening to this, or teachers listening to this, or parents, the issue of the First Amendment is an issue for public schools.
Right.
Private schools are
Are not
really
bound
bound
by-
by the First Amendment.
right.
They're not the government.
Right. So
Public, yeah.
private companies and private schools.
Right.
Look,
Right.
the 49ers fired Colin Kaepernick.
Exactly.
Right,
And they had
right.
the right to because they weren't.
Right. The 49ers are not required to follow the First Amendment because the First Amendment says, Congress shall make no law. And later on, the courts applied that to the states. And through a whole bunch of cases, we now know that any governmental entity, local, state, federal, has to follow the First Amendment. But private schools do not.
Okay. That is an important clarification. The cases we're talking about did take place or come out of disputes in public schools. Okay. All right.
And
So
universities.
So tell us, Grace, let's talk about Barnett first. So just give us a little background on that case and why that case helps inform what we're talking about now.
So Barnett is a case that comes out of West Virginia. The central theme that you should take out of Barnett is that a school board cannot compel students to salute the flag. So it's 1943, it's West Virginia, and the West Virginia Board of Education adopts a resolution ordering that all teachers and pupils shall be required to participate in a salute honoring the nation represented by the flag. And one of the interesting things about this case is that it deals with how you physically honor your citizenship and the flag and the symbols that represent nationalism for us. And they were trying to figure out how we salute the flag. So when you think about taking the knee, this is a physical act. And one of the things we see throughout our free speech jurisprudence is what does it mean to utter your opinion? Because Colin Kaepernick isn't saying anything. He's doing something physical. And this is one of the first cases where we really have to decide, does that count as speech, a physical act with no sound and no utterance? And so we're defining what it physically means to express your nationalism, and they were working through different kinds of salutes. And one of the salutes they had was the stiff arm, which, I mean, we know what a stiff arm salute is. And the PTA and the Boys and Girls Club dealing with in this region rejected that salute because at the time it was too close to Hitler's.
Yeah, incredible the idea that in this country we would mimic, the
Right.
Hitler salute, the Nazi salute.
Well,
But that's how powerful.
Traded for the American flag.
Right.
Well, I mean, not for nothing, but we saw that even in the run-up to the last election. There were at least a couple of rallies, at least a couple of events where people were using that purportedly as just a salute.
Yeah, but this is in school. This
Yeah.
is not some group that may have ties to some right wing,
Right.
or some group like that. These are supposedly educators who are trying to figure out how to have students conduct themselves in a public school
Right.
Right.
during war against Hitler.
Right.
So okay, and I think it's also interesting, Grace, because we probably many of us probably take for granted that we salute the flag, and that there's a
Definitely.
certain way that we should salute the flag
Exactly.
if we're going to be respectful to the flag and what it
Exactly.
stands for. But here in the 1940s, during a war for the survival of our planet, they're trying to figure out what that even means and what it
Right.
looks like.
Exactly. And I think that's one of the reasons why this form of physical protest carries such weight today, because we've really married physical actions with a manifestation of our nationalism and who we are as Americans. The difference between this and being on the knee and, I don't know, what if like this is saluting the flag? You're hugging it's we've really tied this to some really important messages about who we are as Americans. But so in Barnett, any student in the school who didn't salute the flag in the way that they I guess figured out how to salute the flag was going to be expelled. And the people who brought a case against the school district were Jehovah's Witnesses. Jehovah's Witnesses do not believe in, I guess, paying allegiance to anything that is on this physical plane because I guess it would be idol worship.
Right.
So this was against a firmly held belief that these students who were Jehovah's Witnesses had, and they were being expelled for this. So,
But were they making a religious objection? In other words, that this violated their First Amendment rights in terms of their freedom of religion?
it was actually both. So they were making a religious objection, but in the opinion, the court kind of expanded this and said, hey, by the way, these people have this firmly held religious belief, but even if you don't, even if it's just a personal belief, you still can't be compelled to express your nationalism in any physical way in school. So the Jehovah's Witnesses sued really on behalf of themselves, but what came out of this case was the idea that students in school, yes, we want to teach them civics, we want to teach them good citizenship, but part of teaching kids good citizenship is allowing them to define for themselves what it means to be an American. Even something as simple as allowing them to stand silently during the pledge. If that's what's American for them, then you have to let them explore it, especially in this context of, again, it's school, so it's a marketplace of ideas. It's growing up citizens to be, whatever we consider good citizens to be. And it's really, I think this was a good opinion because it established that kids and children can, it established, I guess, a real respect for the First Amendment. Like you want to instill in school kids the idea that the First Amendment doesn't just mean that I can say things like you were saying before that people like or that the majority likes. I get to say and do what I truly believe in.
Mm-hmm.
So that's what Barnett stood for.
So this is interesting too, as you point out, because this is about compelling speech and really compelling everybody to a certain expression of speech in the same way, including those who may not want to. I remember when I was in elementary school, this came up in the context of the Pledge of Allegiance, and there was a time when the pledge did not include the words "under God," and then those words were added, and that created a whole separate controversy because, let's say you were an atheist, let's say your personal or religious views don't allow you to say the words under, or you consider that sacrilegious in some way. So, there were people who would stand for the pledge but would be silent or wouldn't utter those words in the pledge. And so all of these are different kinds of speech and kinds of expression, but at least starting from 1943, the Supreme Court is saying you can't compel even students, even if as a matter of school policy or what you believe is the goal or purpose of education in your public school system, and however you might see standing for the pledge or saluting the flag being part of that, you can't compel even students to speak in a particular way. So that is a really huge opinion in understanding how the law has evolved in this area.
Right. And it's important, I think, just to complete the context here, I think the courts understand that when you have a state, which all of the states, as far as I know, have, where there's compulsory education, the kids don't really have a choice but to be there. It does create a sort of a special context, a special circumstance. The courts seem to understand that, you can't force kids to be here, force these citizens, these people, these Americans to be there, and then just take away all of their liberties, all of their civil liberties. There has to be something left. It's not a totally voluntary situation for them. I don't think that the Barnett Court back in the 1940s was necessarily thinking of it along these lines, but I think what we'll start to see as we discuss the cases as they evolve is that there is this growing recognition that schools are different because the kids have to be there. In many, kind of like in a lot of the employment cases and employment discrimination cases, there's this growing understanding that, people have to be at work, they have to be at the office, and they shouldn't have to tolerate certain infringements on their liberties, on their rights, because it's not entirely a voluntary situation that they're in.
Yeah, I think you're right, and it's so much clearer still in schools because you're right. Kids have to be in school. I think up to, well, it depends state by state, right? But I think in most states it's 16.
Yeah, here it's 17 in Pennsylvania.
Okay.
Yeah.
So let's talk about Tinker next, because we go from a case that said you can't compel speech to a really a true protest case, where a student was engaging in the kind of speech that we're really talking about today with those who are taking the knee, an act of very conscious, very deliberate, even though no words are uttered. There's no spoken speech here. Nonetheless, it's clearly a form of protest speech. And court comes out with a very interesting result. So
Yeah.
tell us, Grace, a little bit about Tinker and
So
what happened there.
Tinker came out, let me just make sure I have the year right here. Yep, 1969. So again, another time of unrest in our country. And it was 2 high school students and 1 middle school student. And the students are protesting the Vietnam War. And so the protest actually starts off campus. The students have a meeting with their families and decide that as a form of protest, they are going to wear these black armbands to school. So around December, they went to school with the black armbands and were told that they had to go home, and they could not return until after they took the black armbands off. And their parents sued, and it went up to the Supreme Court. And what the Supreme Court basically said, and why Tinker tends to be the free speech case that is quoted throughout every other free speech case that we'll read and that we'll talk about today, is because of this famous line: school students don't hang up their First Amendment rights at the schoolhouse door. The idea being that, like we're talking about kids and what kids have the right to do in school. While there are safety considerations and considerations about order, and especially since school is such a regimented type of environment, you go from class to class, there's somewhere you have to be at all times of the day. The court acknowledges the difficulty that the school administration has in trying to make sure that school goes smoothly. And even with that consideration in mind, students still have the right to express their First Amendment free speech rights, as long as they don't run up against the consideration of safety and order in the school district.
And that really parallels too the broader tension in understanding the limits in the First Amendment, where we have this idea that, I can, as you said, Josh, I can say anything I want. The First Amendment gives me that right, but actually you don't, and there can be reasonable limitations. The classic example of shouting fire in a crowded movie theater, or as we were saying before, speech that is designed clearly to incite violence. Let's go get him.
Right.
Right.
To people with carrying guns or something like that would, I think, be speech. It's clearly words, therefore it's speech, but it's words designed to incite violence.
Right.
Right.
And here we have this tension between, as you said, the right to express yourself, or engage in speech, as against a school's interest in creating order and discipline, and allowing its educational program to go forward. But let's talk for a moment about the kind of speech that was at issue in Tinker, because I think there are some very interesting parallels to what we're seeing right now with taking a knee. You pointed out before that Colin Kaepernick and the others who are taking a knee, they're not actually saying anything.
Right.
There's no words involved. And similarly, the black armband, I mean, there were no words on it. There was no, fuck the USA, or, or anything having to do with the Vietnam War, or anything. It was just a black armband.
And it was completely personal. So it wasn't like the school was handing out black armbands or anything like that. These were personally held beliefs. So it was silent, it was personal, and what the Tinker Court had to determine is whether it would be disruptive. Yeah. So when we're talking about the push up against safety and order and then speech, we have to talk about whether or not this speech is either will cause a disruption, or whether the school officials can reasonably expect it to cause a disruption in school. So as the Tinker Court tried to define what free speech rights students had in school, we had to look at very specific facts about the armbands. One of the things that the Tinker Court pointed out was that only 6 students in the school had the armbands. Like you said before, they were silent. It wasn't accompanied by any rowdy behavior. The students weren't in the hall yelling or waving them around or anything like that. So because there was no disruption, the the students exercising their free speech rights did not run up against this other consideration of safety and order, and therefore there was no real reason to limit their free speech rights in school.
Well, yeah, and the reason I wanted to try to connect it to what we're seeing today is because I've been thinking about the significance of taking the knee as a gesture, as a what is that expression? And I was thinking that, you know, as we were talking about in the Barnett case with saluting the flag, somebody decided, in that case it was the school district, decided there is a proper way to show respect to the flag. There is a particular gesture, there is a particular way of expressing respect. But says who? You know, and same with, you know, during the national anthem. We stand, we place our hand over our heart. Said who? I mean, taking the knee, you know, if you meet you know, a member of the royal family, don't you bow? Don't you take a knee? Don't, you know, in other words, some might say that taking a knee actually is a gesture of respect.
Right.
Right.
Or if you're taking the knee consciously to be different from what everybody else is doing, the accepted form of showing respect, which I think is what they're doing. I mean, they're very consciously doing something to say, I'm not going to go along with what they're doing as a form of protest.
Right.
Could it be said that you're showing respect? There goes my cell phone in the middle of our podcast. Keeping it real here on Good Law, Bad Law. If you take a knee, maybe you are doing something different than everyone else is doing. Maybe somebody might see that as disrespectful, but according to your own set of beliefs, maybe you're actually engaging in an act of respect to what you believe the values
Right.
Right.
of the national anthem are all about, or what the Constitution is all about, or what the flag is all
Right.
about.
Well, you hear that in the flag burning discussion. You will definitely hear people say that the most disrespectful thing that you can do against this country would be to burn a flag.
Yeah.
You will also hear people say equally as sincerely, the most respectful thing that you can do patriotically for this country is to burn a flag. Because this is a country where you can do that. And that is the most American thing of all. Is now, you are not going to, the people who believe strongly on one side and the other are never going to agree on that one. But one thing that we can all be clear about is you're certainly saying something when you do that. And when Colin Kaepernick took a knee, there has been this amazing discussion about what did it mean? What could it have meant? What did it mean to him? What does it mean when other people do it? And this brings up a fundamental problem with all of these situations, which is that it's sometimes very hard to know or impossible to know exactly why one person is doing it. You could have three people taking the knee all for different reasons. We saw with the recent issue with the NFL, the coaches and the managers lining up or linking arms, and there was this whole question about what did that mean? Well, was it a general protest about, you know, supporting free speech? Was it a response to the president's criticism of them? Was it just we're standing with our players because they're our teammates? What was it? Was it them saying that we are concerned about the way black and brown people are treated? It wasn't clear, but it got a discussion going. It certainly got people talking about it.
Isn't that the point?
Isn't that the point? And what could be more American? What could be more patriotic than encouraging and furthering civil discourse about these issues? But a lot of people would take it differently. They see it as offensive, and that is always going to be the issue in all of these cases. One person's patriotism is another person's disrespect, and that's the nature of being 350 million people living in the same borders with each other. We are going to express ourselves differently. We're going to, have different views and different opinions. And the only real question that we're dealing with here is, what is the Constitution going to say about the limits that the government has in terms of restricting and limiting how you do it?
Well, now let's come back to Tinker with that in mind, because we said minors are dealt with differently under the law. In the adult world, the cases, and again we talk about this in the coming out of Charlottesville and seeing what happened there, and anticipating other, other cities and other communities where these clashes are going to occur, clashes of ideas, clashes of people. And as long as the speech, no matter how hateful to some, or even to many, or to most, no matter how hateful that speech might be, it's protected under the Constitution as long as it doesn't pose a clear and present danger, as long as it's not clearly designed to incite violence. In schools, and this is what Grace, you were talking about coming out of Tinker, there's this notion that seems less protective of the students' rights to speech and more leaning towards the school's interest in preserving order and discipline with introducing this idea of disruption.
Right.
So as long as the speech, whether it's wearing an armband or some other form of student expression or speech, doesn't disrupt school activities, an assembly,
Right.
a football game on the
Or
field,
just
or whatever,
classes.
or classes, that speech should be protected. And talk about this, because I think this is a really important distinction between the speech
And the,
being offensive, perhaps, to some who then may disrupt
Right.
because they don't like that speech. They might start screaming and yelling and carrying on and getting up or throwing a fist or whatever it might be. The difference between the speech itself being disruptive and others responding to that speech in a disruptive way.
right. And that theme comes up in a couple of our free speech cases, the analysis of the disruption versus the forecast of disruption based on a reaction. The actual protest is silent. But one of the things that the school officials in this case and in other cases are worried one of the things that the school officials are worried about is the reaction. You know, if half of my student population starts taking a knee during football games, will that start rioting? Will that start, people in class bullying each other and yelling at each other? One of the really important things that Tinker does is separate those two. And what we'll have a discussion about later is whether or not that actually is still true today, because there are some Confederate flag cases that we'll talk about later in which having a disruption in school recently can be enough of a basis to say that there will be a disruption later. So,
Well, I'd like this transition right here, because this is, I think, gets at the distinction. In Tinker, they wore black armbands. They gave meaning to that black armband by saying,
exactly.
I'm wearing a black armband to protest the Vietnam War. The expression otherwise didn't communicate that in any way. It might have been just they like the color black. It might have been a fashion statement, but it wasn't because they said, I give this meaning. The wearing of this black armband has the meaning. Here's that meaning. But what if that armband had a Confederate flag on it? What if it had a Nazi flag, a swastika on it? That's, I think most people would say, is pretty abhorrent. That's pretty hateful, because we've been through the Holocaust and because many people understand the Confederacy is identified with slavery.
Right.
So, but we have a First Amendment.
Right.
So how do you look at those differently?
I mean, like you said, those symbols already have meaning. The Confederate flag and the Nazi symbol, we already know what they tend to communicate to others, which is the tendency towards hating a certain, or feeling that a certain group is not as good as another group. So in the Confederate flag cases, one of the things the courts analyze as far as whether a disruption is likely to happen is, has there been a disruption based on this specific symbol before? One of the interesting things about taking a knee is that, and we talked about this before, there's no intrinsic meaning to taking a knee, and it hasn't historically been disrespectful. I mean, they're not giving the finger, and we know that giving the finger is inherently disrespectful. We don't know that about taking the knee or linking arms, or even putting your hand on the shoulder of someone who is taking the knee. But if your hand is on the shoulder of someone who's taking the knee, you're likely trying to say that you support that person. And in that way, these armbands, they, like you said before, they were communicating a specific belief that the students had that hadn't been communicated in a hateful way previously. And that's not true of the Confederate flag or of the Nazi symbols. So I think that that's why the Confederate cases come out in a little different way than
the other thing is that
how did they come? Well, I want to know that. How did they come out differently? Because I don't know anything that is more hateful in just its being and just the symbol itself than a swastika. I don't think anybody could credibly say, oh no, this is about sunshine and daisies and little bunnies hopping through a field.
Well,
the swastika is identified with the with a period of history that we all know. So
but in the cases with the Confederate flag, the students do say that the Confederate flag represents Southern pride and not racism.
I think that's a little bit trickier. And
cool.
I was going to come to that, but stay on the swastika for a moment. What if in the Tinker, example, or fast forwarded to today, student shows up to school wearing an armband or a pin or a T-shirt that has a swastika on it. First of all, I mean, we know from the ACLU and the Skokie case, and even the recent work that the ACLU did in Charlottesville, where they helped the original protesters, those who were protesting the Robert E. Lee statue in downtown Charlottesville, they helped that individual get that permit from the city council in Charlottesville to stage that protest. So, and Reggie Shuford sat right where you're sitting, Josh, and said, I don't like it. I think most people find it abhorrent, but it's protected under the First Amendment.
Right, but there's probably pretty good reasons why that wouldn't fly in the school context.
Okay, that's what we want to understand.
So I think part of it is, look, there's going to always, law is a human endeavor, okay? So judges are people and litigants are people, and so there's always going to be a level of interpretation and things like that. But at least still today, I don't know what the future will hold, there is a very, very, very close nexus between swastikas and violence and intimidation. And the message is inherently laden with threat. And anytime you come even close to threats, to people threatening each other, particularly students, the courts will give the school districts a huge amount of latitude to prevent that. So the student can say whatever she wants about what the swastika means to her. But the fact is that in this context, in this society, people could reasonably look at that, see it, and feel threatened, physically threatened.
So the courts would allow and have allowed the Nazi Party to march with swastika symbols through the neighborhood of Skokie, Illinois, home not only to many Jewish families, but to Holocaust survivors, and say that speech is protected under the First Amendment, but you're saying that a court would not likely allow a student to wear a swastika.
I'll put it this way, I think it's very likely that the student would be free to wear that swastika outside, not in school property, not in a school event. If they wanted to go to a park and walk around with it, I don't see how anybody could they get arrested or anything like that for it. No, it would be clearly protected. The school.
Why is it different in school?
Well, let's think about the differences between a school and the neighborhood, okay? A school, first of all, the kids have to be there. Second of all, they are kids. They are young people. They are literally kind of stuck together in this big box, right? It's crowded. There are people from all different backgrounds in there. And there is this legally recognized responsibility and obligation that the districts have to have an orderly, safe environment. The courts don't go as far as to say that schools, public schools, are in loco parentis, or I'm going to say what it means, in the place of the parents. Okay. I'm not just going to throw around legal terms. Don't worry. They're not. The courts haven't gone as far as to say that public schools stand in the place of the parents, but they come close in some ways of saying that they do have a responsibility to maintain safety and order. And at least in 2017, still, if my son, is sitting next to a kid in his class in 8th grade who's wearing a swastika on his arm, my son is going to feel threatened
Right.
because he understands what that symbol means.
All right,
And
so
Josh,
swastikas are easy. So go ahead, Grace. What were you
just
going
to
say?
add on to what you're saying, schools also have liability. So like out in the real world, and this is a tort law example, if I just a regular private citizen see someone harmed and I have the ability to help them and I don't help them, I don't have any liability. I don't have any special responsibility to that individual. In schools, and we've dealt with cases in which a student was bullied in school and we were able to hold the school liable for that student's treatment, even when that treatment was coming from other students. The idea being that the teachers, the administrators, and everybody who is there to protect, and not only to educate, but to protect the students.
Okay.
And students are under the threat of or schools are under the threat of liability.
And
So I
that's
think
what you meant by in the place of the parent, which
Sure.
in the Latin phrase is in loco parentis.
Right, which I always thought meant the crazy parents, but
Yeah.
it's just me.
the loco parent.
All right, so how is it? All right, so the swastika is probably the easier example. It's sort of it's easy because it so clearly challenges and tests our understanding of what the First Amendment should protect, the most hateful speech, and also easy to see how that could be treated differently in a public school setting, because it is the most hateful speech,
Right.
and because of the different role that a school has, compared to just what might happen in the public square, let's say. What about the Confederate flag? Because I think that people have very strong views on that too.
Yes.
But there are some who do genuinely give it a different meaning than others take from it. So, have there been cases where expression involving the Confederate flag has come up in schools, and how is that treated?
Yeah, and I mean, I'll let Grace get into the details on it, but I think the short answer to the question is the Confederate flag has not found the same kind of protection that a lot of these other forms of protest have, or the other forms of speech, I should say, because I don't want to suggest necessarily that the kids who were bringing Confederate flags in were necessarily protesting anything. They were clearly expressing something, but as it turns out, for a variety of reasons, those courts have not accorded the Confederate flag the same kind of protection as in a lot of these other cases. And I think Grace can explain a little bit more about why.
Well, yeah, and I don't know, we don't have to go through the ins and outs of the particular cases, but I mean, just summarize, as you understand it, why courts would treat that, or at least the courts that have looked at these
Right.
cases. There may be some case coming along that would
Right.
change this,
Yes.
in
It
the
may
future.
change.
It
But,
definitely could
but
change.
historically,
Yep.
what's your understanding of why Confederate flag speech has been treated differently in schools?
I think it comes down again to the responsibility that the administrators have. So in the one case where the student is disciplined for wearing a Confederate flag that actually, I think it says Southern Thunder on the shirt, it's pursuant to a policy the school district has that says no politically charged speech can be displayed on your clothing. So the policy, unlike in these cases where the protesting, where the students are being disciplined for, I guess, expressing a very specific type of view, the policies under which the Confederate flag cases are litigated are just every view, every politically charged view. So in the case where the students were disciplined, it was Confederate flag, swastikas, the Klan, Black Power, anything that had to do with politically charged speech. And the idea is these kids are in school to learn, and they have to have access to their education in a way that they can really absorb the information. And having really politically charged speech that goes from speech into danger and violence stops them from having this access to the material, into the education in a really meaningful way. And that's the first kind of consideration. And then the second is these policies are content neutral. Whereas in Tinker and in the other cases, in Barnett as well, the students are disciplined for having a very specific one-sided political view. So I
Right.
think those are the two
So
differences.
so if a school has a policy that says no T-shirts that express any political view, whether it's in favor of the Klan or love for the Confederate flag or Black Lives Matter or any other form, Democratic Party, Republican Party,
Yeah.
it's, as you said, it's content neutral, and that would include, say, a Confederate flag pin. Then that looks like
Right.
something that a court would approve of on behalf of a school district.
Right. I mean, again, it could change, but
Yeah.
that's what we've seen in the cases where the students were allowed to be prosecuted. It was content neutral, and it was a political opinion that came very close to violence and to scaring other children and stopping other children from accessing education in the way that they would need to in a school.
Yeah.
So.
But you can hear it even even as we try to talk about this, you can hear it in our choice of words, in our language, how difficult this is.
Yeah.
Yeah.
Because you mentioned in your list Black Lives Matter. I'm not sure whether, I think there would be a big debate about whether you would put Black Lives Matter in the same
Right.
boat as the Nazis, the Klan, Black Power. I don't know.
said that because Grace said Black Power.
That's right. Well,
Well,
there you go.
so-
So there you go. So,
So the Black Power group was a part of the case and a part of the, it was a part of the policy. And the reason I brought it up is because I don't think that we can equate the Klan to Black Lives Matter in any way, shape, or form. But I also think that if you are a school district who is going to limit political speech, you expose yourself to less liability if it's content neutral. I think that you don't, as far as giving the other side the argument that what you're actually trying to do is forward a certain political view, you can just squash that
Right.
by making it apply to any political view.
Yeah.
Well,
And-
we see it. We all know there are public schools that have school uniforms, right? They say everybody has to come to school dressed in one of the following ways.
dress code,
Or a
yeah.
dress code,
Yeah,
exactly.
right.
So we know that that's a good example of how, all right, listen, we're going to apply the same, quote, no pun intended, uniform standard to everybody. That's not picking out certain kinds of speech or certain opinions for special punishment or support. And that's different.
Right. And I just want to be clear. I in no way wanted to put the Klan
No, I know,
and
but
Yeah.
equate that to Black Lives Matter and saying they're morally, politically, or in any other way.
But I'm
that's
sure-
Same. I'm just saying if you have a policy that says no speech, no
Right.
political speech, is permitted, you could see how they would include
Yeah.
all of those
Right.
in this, under the same policy. That's
Right.
all I
and,
meant.
and
Exactly.
And that
No, but look, I mean, it's great that happened because this happens all the time in these conversations, right? The courts struggle with these things, and they're always thinking about that next case. Oh boy, what's going to happen if somebody comes in, wearing a Bernie sticker or a Trump sticker, and someone else looks at that and goes, "Hey, Bernie's a commie. That's an offense to our country,"
he is.
or Trump is a fascist. That's an offense to our country.
Yeah.
Like anything could be taken as offensive. Anything could be taken as shocking. At some point, a court is going to have to. This is the way our country is set up.
Right.
Courts, judges, they're the ones that get to decide these things. I mean, I think we talked about Tinker, but I think it's a good point in this conversation to remind ourselves what an absolutely stunning and shocking, in some ways, decision that was, and how it was anything but inevitable that was going to be the decision in the Tinker case. Like the fact that we're analyzing these questions based on a standard that says kids have their First Amendment rights as long as they're not disrupting other people, that is not written in the sky. That came from the Supreme Court.
Yeah.
If two justices had flipped the other way or something like that, we wouldn't be talking about it this way.
Right.
And I think that's important for us to remember here. The rights that we have are the rights that we negotiate. They're the rights that the courts say that we have. That's all we're
Right.
talking about here.
yeah.
Well, let's bring it back to and wrap up with some looking forward. And come back to the taking the knee, because it isn't just pro football players and other athletes. We are now seeing students threatened with being disciplined in school if they take the knee. Some already being disciplined for having engaged in that type of speech. I don't think we've seen any cases yet in our courts, but I can't imagine if this if these if this movement, if that's what it is, continues, we aren't going to see
We will.
this in our courts.
It will be litigated.
And these cases that we've been talking about, from Barnett to Tinker and others, are going to be the foundation for that legal discussion. What is allowable in a school? A high school football player who takes the knee is trying to make a statement in doing so,
Yes.
obviously. There are those who are going to find that disruptive in that they don't like it.
Right.
Yeah, but that's not
But
good enough.
imagine that case coming up in the courts and knowing what we know about where the Supreme Court has gone through the line of these cases as this has evolved and where we are today. This isn't a Confederate flag, this isn't a swastika. It does seem more close to the black armband type situation to me,
Yes.
in that it's passive, there's no words uttered.
It's personal.
It is personal. It's not intended to incite violence or active disruption. Where do you think a court would take that?
I mean, I guess we can answer separately, but I don't see a school district winning that. I don't see a school district winning that kind of case.
In other words, if a school district were to discipline a student on the football field let's start with that example, on a football field.
I would take that case any day of the week.
Me too.
For all the reasons that we've already talked about today. And by the way, we did a lot of reading before coming on to the show today about what other legal scholars have thought and written about this. And there's a pretty broad consensus that because of the standards set forth in Tinker, that taking the knee during the pledge or the national anthem, it's silent, it's personal, and it doesn't in any way disrupt or to take away from other people's ability to express their view.
And that's true even if others who see the student taking the knee then themselves become disruptive.
Right.
It's not the same thing.
And, we didn't talk much about this. We've sort of been equating or analogizing taking the knee to the armband. But there's an important difference that I think makes the knee even more protected than even the armband would be, which is that there's a good argument to be made that taking the knee is in fact refusing to speak. It's saying, I don't want to say these words. I don't want to say, and that, the refusal to speak, and then what we're really concerned about is other people's reactions to that, which is in effect their speech. Now you have to,
action.
or action,
Might be
and
action.
sometimes action and speech, of course, are
Right.
one and the same, and the courts definitely understand that. Tinker was an action, right? It wasn't speech. What we have to do is now take this analysis from Tinker and turn it to the folks that are reacting to the people taking the knee. Is their speech silent? Is it personal? And is it non-disruptive? Well, if they're yelling and screaming at the people who are taking the knee, or they are, acting, however they're acting, you would have to ask yourself, is that protected speech in this context? And the answer in many cases would be no. If you're intimidating other people, threatening other people, making a ruckus, that fails all of the tests in Tinker. Whereas somebody who's saying, I'm not, Colin Kaepernick could say, I'm not speaking at all. This isn't speech. This is me refusing to speak in this context. Now, he hasn't said that. I'm certainly not making that argument for him. But what I think we have to do and remember in these contexts is the folks who are unhappy about people taking the knee, the teachers or the other students or the administration that might be unhappy, their objection to these students is speech. And it has to be looked at in the same framework. It has to be analyzed under the same standard as those students' actions would be. It's not fair just to look at the students. These students passed the Tinker test with flying colors as far as I'm concerned. If there are students out there who are thinking about taking the knee or who have, and they're in public schools, if you're in private school, don't listen to any of this because private schools can do whatever they want. If you're a public school student and you're thinking about taking the knee, just remember the lesson from Tinker is do it quietly, do it respectfully, don't cause a disruption, and don't in any way make it seem like you're speaking on behalf of the school. You're doing this for yourself.
Right.
And if you do it that way, then all of the case law that's out there should support your constitutional right to do that in school. That doesn't mean you're not going to get in trouble. That doesn't mean you're not going to have to deal with the consequences of that and the blowback from other students. All of that comes with the territory. But it means that the Constitution respects your right to do it, and that if push comes to shove, the law is on your side.
Well, Judge Kershenbaum, we shall see. This has been a great conversation, guys, and I want to thank you. How can people get a hold of you guys if they have questions, if they want to reach you, if they want to contact you directly?
Well, our website is www.mykidslawyer.com. You can get our email addresses on there. I'm Josh at mykidslawyer.com. Grace is Grace at mykidslawyer.com. Probably the best way to reach us.
Fantastic. Josh, thanks so much.
Thanks so much, Aaron.
Great. Grace, thank you very much.